can we start? Thank you so much for being here. I would prefer to have you here in person again in Lisbon at our law school, but unfortunately, as you know, it isn't possible. And it also brings the possibility for Simone and Cristina and Sara and Gonçalo and Concheta, who is also in Italy right now, to participate in your class. So it's not only disadvantages coming out of this situation, and we don't know yet when it is going to be fixed. Though it's a great pleasure to have you here again. For our students of law and technology in the first semester, you already know Professor Arno Loder. He was here in Lisbon in November, I think, in one of the of law and technology about the algorithms and everything. And Professor Arno Loder is also cooperating with us with the Nova School of Law, and next scholar year we'll probably share a class, a course on emerging technologies here at Nova School of Law. So it's a pleasure to have you here. I don't think you need a more greater presentation, as everyone I think knows you now. But you are from Vrije University in Amsterdam, and it's the first seminar where the presenter, the lecturer, is outside of Lisbon. So it's also interesting to see this working, as Fabrizio and Madalena, they were both in Lisbon when they give their seminars. They were at home, but in Lisbon. You are in Amsterdam.
Yeah.
It's good.
Yeah, I had a plane. The plane was actually on Thursday. It said it would fly, but on Friday it was cancelled. But there was still a plane going to Lisbon on Friday. But
on Friday? Oh, okay.
I thought it was wise to travel.
I think we have 12 flights at the moment to Portugal only
per day.
Only, yes.
Yeah.
Per day. It's
really, it's not very smart to travel.
As we know, I live near the airport. As you know, the airport is in the city, and near here we are always listening the planes coming.
Yeah.
Peaceful.
It's quiet now.
It's really quiet. Yeah. So, the floor is yours. I will ask again if Martim, João, Concheta, Pedro, Helena, Letícia, Gonçalo, Francisca can turn on their cameras. Thank you, Martim. I think it's much better to see your faces. And thank you, Arno, for keeping the class and being here. Thank you, Letícia. Yeah. Also, thank you, Pedro. So.
Okay. Yeah, very, very interesting experience. Thanks for inviting me here also online. I never did it before in an online class. I did do classes in Second Life, but then we were avatars, so we didn't see each other. But never, and I did record classes, which weren't that successful, I think. Once did a class on online dispute resolution for an e-commerce law course, and I still have it on YouTube, but it's more for if people want to laugh about something, then that's really a good recording. But, so I'm very curious how this will turn out. I've been warned over the last couple of days a lot about Zoom, actually. And yesterday my cousin said it would be a nice topic for a class, Zoom and privacy. But we're not going to do that today, but it's maybe something we can think about too in terms of e-commerce. It sort of links in also with the first lecture in this series by Madeleine Narciso, Data's Counter Performance, because Zoom is free. We don't have to pay for it, but there's of course a lot going on behind the screens. And that's one of the things they advised was not have your own background. I don't know why. Maybe they're now gonna find out what books George is reading and then do suggestions about the books he's reading. I don't know. Because the last week I also had a Zoom and then I had my own books in the background, sort of to show off. But So I think it's a very, very interesting set of lectures, digital contracts. When I first saw the name, no, this is not this one. I can't see what I'm going through, so maybe it's sometimes a bit. Excuse me for that. I have two links to the first and the second class. The first link is to the first class because it was about using data as a means to pay for products, and in terms of consumer protection, that's of course very interesting because I'm not sure whether that's in all countries the case, but in the Netherlands, consumer purchase, so buying things, is defined in the law as a special sort of exchange, namely the one where you exchange something for money. And there has been discussion also when people would paying with Bitcoin, whether consumer protection law would apply, because if Bitcoin wouldn't be money, then it wouldn't be consumer purchase. So that was a very interesting topic. But I think it has been covered now by this new directive that has been discussed in the first lecture. And it reminds me also of the famous Papa Savas ruling about services, where the services could be, so service of the information society, the central concept in e-commerce law directive, for amongst others. Whether it would be necessary to pay for a service to call it an information society service. And the scholars were already convinced in 2002 or 2001 that, this is a quote from my own book, that it could also be covered by advertisement or by data processing, and then it still would be a service in terms of information society services. But the Court of Justice confirmed that in 2014 in the Papa Savas case. So that's an important case in terms of making clear once again that it isn't necessary that you really pay for a service to call it an information society service. And then the second one, I'm not sure, I forgot why it links in with the second class, but when I saw that the name of the course, digital contracts, I was thinking, why isn't it called electronic contracts? It also reminded me of one of the first regulations in this field, e-signatures directive, because when they started drafting it, it was called in 95, 96, because there were laws in Germany and Italy about electronic signatures that were not in harmony with each other, so they tried to harmonize it for the European Union. It's interesting to think about it. Like 25 years ago, they were already thinking about regulating electronic signatures. And last week, someone was saying, shouldn't we regulate electronic signatures? Because he had problems using electronic signatures. So I replied, well, we already have a law for more than 15 years saying that, for instance, a name under an email counts as a signature and can be used for concluding a contract. But the reason why the digital signatures directive proposal turned into the electronic signatures had to do with technology, because the encryption, the public key encryption, is called a digital signature, and is a specific signature. And although the most advanced qualified signatures are still digital signatures, it's defined more loosely and can also, like I just said, cover the name under an email. And then I was also looking into what the EU is doing lately, and I thought that digital contract is actually a far better name than electronic contract, because they're talking about shaping the digital market and also digital you. I think that this digital you lines in with the second class. I forgot what it was about, the second class, but the digital shopping and what was the second?
It was about the personalization of prices.
The personalization, exactly, because that's it. Since December 2018, online shops can no longer refuse you their goods or services based on your nationality or where you live. So they always, I think that it's still, I don't know this directive too well, I must admit, but it used to be the case that, for instance, people using an Apple laptop would be asked higher prices than people using another laptop. And I'm not sure whether that's still possible, because that doesn't have to do with nationality or where you live using an Apple laptop. So in particular for a student that doesn't have much money but got this Apple laptop, it can be quite harsh to be asked to pay more if you don't have that much money. But so I'm not sure what's exactly in the, but it links in at least with digital shopping, the second class. So we're now today in the third class, and I normally introduce myself a bit, and then I use some reference to the literature, and I was thinking about it, and I thought it was very interesting that in this some general, a general comment about Christina is also in this book actually on the Payment Service Directive. These are two references to the general introduction to e-commerce and article by article comments to the e-commerce directive. But yesterday I was thinking about that I wrote about the topic of today, information requirements in 2002 in relation to intelligent agents. And that's interesting because we were thinking back then it would be a technology that could really change e-commerce, those software, intelligent software applications that could do all kinds of things for you, including contracting. And what this article was about, because a website is of course not a human, and that's also the reason why we have those information requirements, or one of the reasons. The article was about how you should interpret the obligations to communicate the information and how you should communicate the information, so how you can fulfill the information requirements if an intelligent agent is contracting on behalf of a person. So if you have this software application and ask it to look on the internet for a cheap book and it's contracting, should it also be given the information that is required based on the law? And if not, does it have consequence for the contract? So it was an interesting topic back then. And it remained apparently because in 2006 I was writing about the access of agents to websites and taking server time, etc. But I think over the last 10, 15 years, there hasn't been much going on about intelligence agents. It's totally disappeared. But 5 years ago, I thought, let's do something again about agents, and I did it in the context of the smart grid, because then you could discuss how, in particular, electricity that people generate. There's also sort of e-commerce. So that's the idea that people have, that you can sell if you have too much energy that you can't use yourself, you can store it, that you could sell it to your neighbors or whoever wants the energy to have. And for that purpose, you might also use intelligent agent, because it's easy if you don't have to do it yourself, but some software application can do it on behalf of you. So then I really like this annex, because that's where it all started. So the topic of today, the information requirements, it all started in 1991 with the drafting of the distance selling directive. So the consumer directive we have today from 2011 is the successor of the distance selling directive from 97. And one of the reasons, so it all started with door-to-door selling, but then in case of door-to-door, you still have the physical contact. You can still see someone who's coming at your door and sort of estimate whether you can be trusted or not. But if you have commerce at a distance, you no longer see the person you're trading with. So that was something that the European Union was thinking about how to address that you don't have contact with the person. And also another thing was the touch and feel. So if you have this mug, for instance, I can now touch and feel it and how it drinks, etc. But if you see it at a distance, it's difficult to find out, and also the measure, even if you have the exact size, it can be different from what you expected. So that's the reason why they did the information requirements, so that it should be informed about the main characteristic, etc. And also the legal right of return, so that you have a legal right to return this item if you order it from a distance. But the initial focus of this directive was not on e-commerce, not on internet commerce. That's what you can see from the annex, because the annex was, I think, drafted in like the beginning of the drafting of the directive. It was finalized in '97. Then there was a little bit of e-commerce already going on, like Amazon and these kind of providers were around. But it's funny to see the list like video phone, telephone with screen, video text, microcomputer, and television screen. They were thinking about back then as means to conduct distance selling. And one of the main, I'm not sure whether it's true, but I've heard it often, that one of the main reasons to design this distance selling directive was the television, the teleshopping. And I have a picture in my slide of Amazing Mike. The older people might know him with his amazing products. And then the idea was that people would come home at night, for instance, half drunk and sitting behind the television watching these products that could clean everything or could make them into a very powerful person with a workout set. And then they ordered it, and then like 2 days later it arrived home, and they were thinking, what did I order? So that was one of the reasons they thought there should be regulation in place that you have a right to withdraw from these kind of contracts that you conduct at a distance. But over time, in the zeros, as these years are sometimes called, so between 2000 and 2010, more and more case law from also the Court of Justice of the European Union appeared, and it was mainly about e-commerce. So initially this directive wasn't meant for, so email is mentioned as the only one that refers to the internet, but internet or e-commerce isn't mentioned as a means of communication. But this is an example. It's not an exclusive list, although you can see it from how it's worded. Means of communication covered by. You could, because there's also so much mentioned, you could consider it an exhaustive list, but it isn't. So also internet, and that became the main focus of this directive that now has been replaced by the consumer directive. Then 15 years ago, I thought that we were doing quite okay on the internet in terms of shopping, because one of the ideas also of the information requirements was that people needed to trust the internet, need to trust e-commerce shopping, and otherwise the idea was they wouldn't be willing to shop online. So that was the main driving force of those regulations. And my impression was that back then, like 15 years ago, that consumers know what websites you can be trusted, that you can estimate the risks of buying something somewhere, and that trust isn't essential anymore an issue for e-commerce law issues. And then the e-commerce, the distance selling directive and the directive from the e-commerce contributed to this. But then 1 year later, European Union was still complaining, maybe they were complaining, but they were still saying that it doesn't take off that well, e-commerce, and that we need more rules to generate the trust by consumers. And one topic that has been returning over the years, there's some references also in the chapter by me and Murray in the book I referred to earlier. So this is an example from 2007, although the quote says 2011, so I'm not sure, but there are many of these from 2011, 15, etc. The European Union always believes that cross-border e-commerce isn't taking off the way they expected it to be taking off. So their idea was e-commerce, and it makes sense. If you don't need a physical store, why wouldn't you buy in Portugal, for instance, or why wouldn't you buy in Greek or whatever? So that's a logical thought, but apparently the most consumers buy from their local online shops. So in the Netherlands, and that's probably true for most countries, like 80 or 90 or maybe more % of the online purchases are purchased at a website from their own country. And that's something the European Union wants to stimulate. And I seriously, I don't understand why they keep on pushing so much on it, because I don't believe that what they're doing helps in getting people buy outside their own borders. Because the reason I think they're not doing it is that they know the local brands, and they know also that they can go somewhere, for instance, in the Netherlands, if something goes wrong. Because if I order something from Portugal, it can be quite burdensome to return it, for instance, to begin with. So I'm not sure whether the initiatives the European Union makes can remedy what they consider a lack of cross-border e-commerce. There has been, I'm not sure what the status is. I think it hasn't been finalized yet, but maybe one of you know about the parcel delivery. There was a regulation once proposed, because one of the issues they aimed to tackle was the prices. So if you buy from Portugal, or from Greek or wherever, that the prices of deliverance would be high, and that there was a regulation, at least a proposal, but I think it might maybe even have been finalized. I think it has been finalized, that there was a maximum amount you could ask for delivering products, so like a couple of euro. And that, of course, that could be something that helps to stimulate the cross-border trade, although still, I think people like to have their local websites. And a very clear example of it is, although it comes quite late, but they have Amazon in Germany, and since a couple of months, I think they now also have Amazon.nl. And that's also because people, Amazon.com, for Dutch people, of course they buy there already, but if it's Amazon.nl, they probably buy there sooner. So I'm not sure whether what the European Union thinks and what the European Union is doing in terms of stimulating e-commerce, whether it really helps. Also, if you look at, because the cross-border trade to China, now it's maybe a bit less, but all the Alibaba transactions, people don't care that it's abroad, also because the cost of deliverance are low, of course, and the prices are low. So I'm not sure whether all the legislation that has been put in place by the European Union really is something that will change the behavior of consumers. So I'm not saying that it's unnecessary what they did. I think it's several, in particular, information requirements that we will discuss make sense. But overall, there should be a sort of rethinking of the European Union, I think. So, what are my class objectives? I want to discuss the main information requirements on name, contact details, and what I labeled E-terms, so the contractual aspects of information requirements. And because it's linked to the topic, I hope I don't, contract formation is maybe probably also in others. Classes in this course, so I will not say too much about it. And is the right of withdrawal in other classes, or you're
in my classes?
Sorry,
in my classes, not in seminars, but
okay. And I will also put it. I don't want to say too much about it, but it is what I will say is mainly also focused on.
No, but you can
indication of this right of withdrawal, so more related to information requirements. The background of how I discuss it is a consumer taking service from commercial websites, and a bit in line with what I was just saying. It's interesting to think about this topic and determine for yourself whether everything that's regulated is just fine. Maybe some things need to change, or what a mess, lots of work to do. So it's an evolving topic, and you can really think about what, in terms of regulating e-commerce, maybe should be done still, or maybe should be cancelled from what's there right now. So these are then the basic legislative instruments of the European Union I will discuss. The first is about consumer protection, the directive on consumer rights that recently has been amended in November 2019 by a directive that primarily in terms of information requirements is about information requirements of online intermediaries or the platforms that I will briefly touch upon that too. But the basic norms of the directive from 2011 are still in place. Then you have the e-commerce directive, and the main aim of this directive is to stimulate e-commerce and trust, the trust element I mentioned before. So it has both this internal market aspect, so to stimulate the trade between the different countries within the European Union, different member states. And do that by getting people trusting this medium. And then there's the service directive that also several transparency and information requirements from 2006. And information society services are services, so that's why this is also relevant for e-commerce. And this already shows a bit. That's the paper that's part of the material of this course discusses that there is a lot of information communicated to consumers, and that's why I call it information requirements overload, because these are just 3 directives, central directives for this topic, but there's much more. I mentioned here the unfair terms and unfair commercial practices, but there are also more domain specific. If you, for instance, look at financial services and all the information requirements that are applicable to those services, it's really very much that has to be communicated based on these directives to the consumers, and it's questionable whether consumers really need it, all this information. Maybe it would be better to just focus on the main information elements, and that's what the European Union did a bit in the consumer directive by focusing on small screens and things, so the more the app kind of transactions. Although if you think about the information that's communicated when you install an app, that's not that much, and not really complying with all kind of information requirements from, for instance, the e-commerce directive. So to mention just one that will be discussed in this class, the name and the location of the service provider. I'm not aware of apps that really clearly, directly, etc., communicate where they're physically located. If you install an app, for instance, or if you purchase an app. So, and I'm not sure whether that's so that's the things you should think about whether it's really necessary. In the past, and there are also situations where it even doesn't make sense. In the past, I gave the example of people doing commerce in a virtual world. If you buy a virtual wig, for instance, in Second Life, what does it matter where the person who sells you the wig is physically located? Does it matter at all? You can really doubt that, but because the legislation is technically neutrally defined, it applies to these situations, but you can doubt whether it makes that much sense. So there's a lot you can think about in relation to those information requirements, but for this class I want to concentrate on the classic website where in particular the e-commerce directive was drafted for. So the terminology is quite neutral for how to communicate the information requirements, but the legislator clearly had this classic website in the back of his mind, just this single provider of the service. And that's why, for instance, also there has recently been a lot of new regulation from the European Union for more complicated situations. So the platforms, if you offer products or services via a platform, you sometimes aren't even capable to comply with the information requirements because technology doesn't allow you to communicate the information in a way that is required by the law. So that's one issue that's interesting to consider, but it hasn't been taken into account in these kind of regulations, because the idea was you would have just the sort of classic Amazon that sells their products. It's no longer the case these days, even with Amazon, but because you have lots of traders on Amazon as well. But what you have seen recently is the requirements. So in this directive that I mentioned here from 2019, that is about sharing information by the platform to the consumer about who is selling and offering products. And there's another one that I don't mention here, but I mentioned in a later slide. It's a regulation about the data that the platform should share with the person who offers the service. But that has to do with the information asymmetry, because the owner of the platform has all the information about the transaction from both buyer and seller, and the seller only has the information. It doesn't have this complete picture, so he's in a sort of weaker position. And an interesting example in this context is the Uber driver. He doesn't get all the information that Uber has, but based on this regulation, Uber should share more information with the drivers about how to make their prices and all these kind of things. So there's a very interesting new regulation in terms of sharing information about the contractual process, but I won't discuss it in this. This is actually what I was just referring to. So I mentioned this new directive from June 2019 on promoting fairness and transparency for business users of online intermediation services, and that this also applies to the Ubers and the Airbnbs of the world, so the more platform economies. And this is just an exercise to see the complications that initially weren't thought about when for instance, the e-commerce directive was drafted. So with a platform, you have the platform that is an information site, a service provider, for instance, eBay, has to comply with the e-commerce directive. And then there are different contracts between the platform and the recipient and the buyer, between the provider and the seller. And in this, in the vertical direction, several legislations apply. For instance, the e-commerce directive in the context of the platform to the provider. And I say not the consumer directive, but it's because the first two examples are businesses, but if it's a consumer, the seller, then also even the consumer directive might apply. But there you touch upon the topic of the quote of Christina Riva also, that the consumers, if they sell a lot, they might suddenly become a business without even knowing themselves that they are a business. But that's in consumer, there are other people that know much more about it when a consumer becomes basically business. But that's something that plays a role, of course, on those platforms as well. And then I divided the quality of the provider and the recipient in business to consumer, business to business, etc. One thing you see is that the e-commerce directive isn't applicable to business. That's the basic idea in terms of information requirements, except otherwise agreed. So if they want to apply those information requirements, they can, but I assume, I don't know from practice, but I assume that they never will agree about it. They will just think it's fine and don't apply the e-commerce directive. So, when discussing the different topics of this class, or the three I mentioned in the beginning, The first is about informing yourself. That's so about the information requirements. Then about concluding a contract, which is also related to information requirements, and then withdraw from the contract, so the right of withdrawal, the right of return. And there are also mentioned some specific elements related to communicating information about it. Information requirements. Let's take a... How long do you want to have the sessions for the... Do you want to have breaks or?
We usually have a break at 10:15.
10:15, okay.
Okay, but you can, if you want to, we can have a break now and start. You can manage as you want.
Okay. Yeah. Maybe a short break, 10 minutes or so. Is that okay?
Yes. Okay. Okay. So we will be back at 10.
Okay.
No.
Yeah.
Okay. Yeah. So see you in 10 minutes.
Yeah. Okay. Thank you.
Hi, Dad.
Hi, Conchita. How are
Yes,
you?
I'm fine. Thank you. Thank you for sharing this class with me.
No, it's great. It's great. How are things now in Florence?
Yes, they are pretty much the same, actually. Nothing has changed so far.
Unfortunately,
Yeah,
like here, we are also closed at home for more than 2 weeks now.
exactly.
Okay, it's great to see you
Thank you.
again. So Arno, do you want to?
Yes. It's paused. No. No. You can see now information requirements. Huh? Yeah. Okay. So information requirements. So when we're talking about information requirements, you basically have to ask at least 4 questions, because there's also a preliminary one: who provides the information and to whom, as was explained, for instance, in the eBay overview. First, what information has to be provided? So that's the substance of the information. How it should be provided, in what way, by what means, when, what moment, if you talk about contracting, before the contract is concluded, after the contract is concluded, maybe at the moment of delivery, and what happens if not. In particular, the how, and I gave some examples in the chapter on the information requirements overload. In particular, how is interesting to look into, because there are many different formulations in the directives that have subtle differences, but that is not totally clear what it means. And I think it's particularly difficult can be difficult for providers, that they don't know exactly how they should communicate their information and when they do comply with the information requirements and when not. And it has become more relevant in recent years, in particular the last 5 or 10 years, because the sanctions in the first 5 or 10 years or so, in the zeros, there, in particular between 2000 and 2006, 7, 8, there weren't much sanctions for violating those information requirements. But we have seen after that, for instance, in the Netherlands, not easy yet, but the other cheap, Ryanair, got a big fine for not complying with the information requirements, and there were others. So there is now in the Netherlands by the Consumer Authority, and I think that's applicable to more countries, that they really also look into the information requirements, whether they are communicated in a correct way. There is something that's not here, but that has meaning to me, at least. I'm not sure whether it's legally relevant. For me, it should be legally relevant, but the enforcement might be more difficult. That is, if you provide the information, but it's useless. So if you, for instance, provide a telephone number, but it's never answered. So then you comply with the information requirement, you provide the information, but when the information is used, you always get an answering machine, for instance. And that's something that's not part of this information requirements law. And I see that as a shortcoming, although I can understand that in terms of enforcement might be very difficult. We had a very famous e-commerce company in the Netherlands in terms of case law in the zeros. It was a porn website, and they they actually misused the right of withdrawal period. So they sold free trials, and then you had to resign by normal post and official letters, etc. And if you didn't do it in time, and you were informed normally after like 3 months, if you didn't do it in time, you have to pay a lot of money. There have been at least 25 court cases, and I think all of them lost by the company. And then you might think, well, why would they do these court cases? Well, I think that most people, why do they have this business? I think that most people, because it was a porn website, didn't dare to start a dispute. So that's probably why they could still make profit. And the reason I mention it now is that they had on their website where they were physically located. So they complied with the information requirement that you have to indicate where you are established. I was once called by someone who had contact with this company, and he paid like €500 to get rid of it, and then got another thing, and then he was thinking, yeah, well, I'm not going to do it again. And then he went to this physical location, and he found a house with a sealed. There was nobody living there, a sealed post box. So then you have this physical address, but it doesn't mean anything. And that's in particular with physical addresses difficult to determine whether it makes sense. But in terms of why the physical address is there, is because it should be valid, of course. So, but that's probably on purpose because of enforcement reasons. It is included in the regulation, but you should keep in mind that the information requirements are in general, it's some more and some less are of relevance, but keep in mind that it not necessarily means that the information is correct that is provided, and that's difficult to check. So the name.
No, I don't know if we are seeing your presentation. We only have information requirements and it's empty.
Okay. Yeah, sure.
So if you can share it again,
Sure.
Probably a good idea.
You see it now?
No.
Now?
Now it has changed. No.
You see it now?
Yes. Yes.
Ah, okay. Okay. Sorry.
Sorry to interrupt.
Yeah. So this was what I was just discussing about the what, the how, and the when, and what if not. So the name is the first one. The idea why it's important to have a name is what I was saying in the beginning, that you are at a distance with the e-commerce trader. You don't see him and you don't know who he is. So it's important that you know who you're dealing with when you're contracting, for instance. So the name is a very important aspect of the information that should be disclosed. And it's also something that should be clear on every page you are on the website, because and that's why they have in the, just looked it up for instance, e-commerce directive. They say the information shall be provided easily, directly, and permanently. And easily and directly means also that no matter what page you're on, this information should be available. Because if you're searching on if you're using a search engine, you can enter a random page of a provider, and if the name wouldn't be there, you wouldn't be sure who you're dealing with. So that's something that's very important. And you can also compare it, if you compare it with a physical word to what's on top of a shop, for instance. If you enter the shop, you want to know, if you know what shop you're entering. You see that the wording is a bit different. So in the service directive, it's also the name of the provider. In the consumer directive, they talk about the identity of the trader, such as his trading name. And I never really understood what's meant by that, because such as seems to suggest that's more to the identity than a trading name. It's broader, but what it particularly implies, I think that in the distance selling directive, it was only trading name still, so that it changed over time. I have no idea what the exact meaning of the identity is, and so I don't know why they phrase it like this, I must admit. So to me, if you are a trader and you would read this information requirement, you might think that you should provide more information than your name, because it says such as your trading name. But what that would be, I have no idea. I really have no idea. But so that's an interesting thing to. I never could figure it out. Maybe someone knows, but I don't know. I singled out the one for the lawyers here, particularly the sub F of Article 5.1 of the e-commerce directive, because it's interesting. I looked at some law office websites in the Netherlands. So then we talk about lawyers that should know the law, but even they, and remember, also this information should be provided easily, directly, and permanently. You can check in your own country. I don't think that many law firms comply, and that's in a way ironic, isn't it? That the professional actors that should know what they have to do don't comply with the information requirements. More in general, there always have been researches over the years, and the name, of course, the name is normally provided. We will discuss other information items that are not always provided, and I don't think that it's always on purpose, but it's also because there's so much and people don't know what they have to provide that sometimes information is missing. There has been an interesting discussion in the Netherlands about the VAT number. And then there's been a court case last year because one of the information requirements from the e-commerce directive is that you have to provide, again, in this easily permanently way, your VAT number. And I remember from long ago that tax lawyers were a bit surprised about it, because in terms of tax law, it apparently is data that you not easily share to the whole world, or shouldn't. I don't know why, because I'm not a tax lawyer. But in the Netherlands, it had an other interesting element, is that the civil servant number was part of the VAT number of people without, self-employed people without personnel. So the people working on their own, their VAT number included their civil service number. And the government told them, even if you make a copy of your passport, don't let your civil servant number be copied. It's a very delicate number, apparently. But they, on the other hand, they didn't mind that people would share this as an information requirement based on the e-commerce directive on their website to the whole world. But the judge has ruled last year that it's ridiculous and they should stop this practice, and they now stop this practice. So the VAT numbers has been changed in the Netherlands. So these are the basics. The name you're dealing with is important, and then maybe even more important is how can you get in contact with the one you're dealing with for if something goes wrong or if you want more information. And the contact details in the e-commerce directive are about the geographic address. So in the distance selling directive, there still was a requirement about I'm not sure, I think it was an address that they say it like that, and then a post box could comply with that. So that's why they changed it in the e-commerce directive to geographic address, so that you really could go somewhere. As just discussed, sometimes people use geographic addresses that doesn't exist or aren't being used, so then you still, it doesn't mean that much. But basically, it's important to know where you can reach the one you're trading with, and that's also why an additional information requirement is about the register, in a trade register, that you should provide that number. So then you can check whether this company really exists. And that's something that can be important if you don't know the company you're dealing with. Then you can get more information about it outside its own website. So if they provide this trade register number, you can go to the trade register and check if you are suspicious or whatever. Then what's also, so the geographical address is you can send summons to it, etc. So it's also for litigation purposes and for being able to complain at a physical location. That's also why a geographic address is important. But next to that, you might want to reach the provider in an effective way. So that's why the e-commerce directive requires that details, including email, are provided that allow for rapid contact that is directly and effective. And here, if you see the direct and effective, then a phone number that links to an answering machine is not effective. So then it doesn't comply with the information requirement. The question is whether the people who enforce the norms will go that deep. I don't know. But if there is a complaint, then they might look into it, and they might order the company to have an effective way of direct contact. In the European, in the European Court of Justice case law, there has been a case about what exactly is meant by the details, including the electronic email address, which allow him to be contacted rapidly and communicated with in a direct and effective manner. There was a court case where the claimant was asking whether including email also meant that you have to provide a telephone number, because including seems to imply that there's more than only email details, including, so you should provide an email, but and the Attorney General was in his advice concentrating on the effective and direct manner of the communication. So saying, well, if you provide an email and it works as a direct and effective mean, why provide other contact details? But the Court of Justice was saying, well, you should, under all circumstances, provide an email. And that's one of the information requirement elements that's interesting to look after when you visit websites, because there are quite some websites that still today don't provide an email address. But it's clear from this article and also from the case law that you should provide an email. And that, for instance, a form where you can react doesn't satisfy the requirement of an email. And one of the reasons behind is that you can use your email program to email people, and you don't have to be in the website. So it's a more effective way, you could say, to contact people. The reason some providers don't mention their emails, for instance, spam, that they don't want to be spammed, and that's why they don't want to mention their email address. But legally, it's a requirement. So that's one thing you always should present to the recipient in a easy, direct, and permanent accessible way, your email address. And the court then ruled in 2010 or 9 or 8, I'm not sure when it was, there should be at least one other, because it says including, there should be at least one other means by which the provider can be contacted direct and effective. Can be a telephone number, but not necessarily. It can also be a form, an email form, or fax number or whatever. So, but there should be at least 2 ways the provider can be contacted. If we then look at the Services Directive, again, the geographic address, so that's the same as which is established, and deals enabling him to be contacted rapidly. So here, and communicated with directly, so rapid and direct, not effective. So that's interesting. So maybe if you have this answering machine, it complies with this requirement, because you have then rapid and direct contact. It's not effective because you just have this answering machine. But, and as the case may be, by electronics means, well, these days normally service providers will have electronic means. So the case will always be, I think, but there might be exceptions to this rule. I don't know any of them, but it could be. And the same is case here you see in the Consumer Directive from 2011, the telephone number explicitly mentioned. So not only email address, but so also telephone number. So that's not what the Court of Justice ruled, but was laid down in the Consumer Directive. So that's a change in regulation. That is in particular can be burdensome for people trading on their own. That they often don't want their phone number to be on their website, because they can get phone calls 24 hours a day, and they don't want to be contacted in that way. But based on this this directive, they are obligated to provide this information. So telephone number, fax number, and email address. But then again, they have this where available. And I don't know of any cases on this topic, but I can't really think of a valid argument where you could argue as a trader that you don't have a telephone number. I don't think that anyone would be convinced by that argument, that you say, well, I didn't provide my telephone number because it isn't available. And there has been a change recently in the wording of this article that opens the discussion again whether the telephone number should be provided under all circumstances. But in my opinion, as it is defined, where available, for fax number, it makes sense because not everyone has a fax. But email address and telephone number, I don't think you can ever argue that you don't have it available. So that's, in my opinion, you should always be able.
Don't you think you can state that, or you can establish in the web page that you are not available to be contacted by telephone? Don't you think it can mean that if you can decide, you as a trader can decide if you want to be contacted by telephone, and that's what where available means. I don't know. I'm just.
Yeah, it's interesting interpretation.
Someone else wants to ask a question, but.
Yeah. That's very interesting interpretation. but that would mean that the email address you don't have a choice because you have to provide it anyway based on the e-commerce directive.
Yes.
So that already, I think.
I'm not sure. I'm not sure.
Sorry? What?
I'm not sure about about that being the interpretation, but I think this wording leaves space to that interpretation.
Yeah, it's interesting. Where available. Yeah, but I don't. Yeah. It's so. I have argued in the past that the most important thing is that you can reach him quickly, effectively, directly, etc. So that the phone number doesn't necessarily contribute to that. If you have an email address where you get immediate response, that's fine. But yeah, I don't. You can argue that where available means that you don't have it available because you're not using telephone numbers business, so to say. But I don't think it's what's meant here in the article. Maybe you can convince a judge about it.
Let's see if there
but
is.
I think that the rationale of this article is that you should provide it if you have it.
You will always have.
Yeah, that's what please for your interpretation, because everyone has a telephone number and email address, but because it's in the series with also fax number, it could make sense. But it's a strange formulation anyway, because you could then also, if my interpretation is correct, when you could have better drafted this, and the trader's telephone number and the trader's fax number were available, and telephone number and email address. That would then make more sense if my interpretation is correct. So maybe you're right.
I don't want to be right. I was just
it's
okay.
That's interesting.
Simone,
it can also be poorly drafted, so that
it's probably. Simone and Sophia wanted to ask questions. So first, Simone.
Okay. Okay.
Yeah, thanks for the possibility. Well, I really do not know what happened in the other law systems, national law systems, but however, for the Italian experience, it is mandatory for the traders today to have a special email, and it is a certified protocol email. So it means that it has the same it does the same relation to of a notification, of a law notification, for example, and it is not allowed for an Italian entrepreneur or a professional, so or an enterprises not to have a PEC, it is named. So this kind of disposition of the directive is totally bypassed for my law system. Okay. I don't know what happened in the other law systems. I already know that for this is a unicum, we can say, in the European Union and in the European environment, but I really do not know if it is not mandatory for other law systems not to have at least an email where to contact the trader, especially for the e-commerce.
Yeah. So, but you say they have a special type of email?
Yeah, this kind of special type of email is concerned the fact that when you want to register your enterprise at the Chamber of Commerce, for example, you must have this kind of email address. But the specialty of this email address consists simply in the fact that it is not only an email, it is an email, but with an established certification. And so each kind of communication you send to the trader or every kind of communication is exchanged between the trader, the consumer, or even the businessman or other traders. So a B2B or a B2C market, this kind is a proof. So in a judicial or in a cause, of course, in a pledge, you can take it and prove the fact that there has been a communication and it is valid, of course.
Oh, okay. Oh, very interesting. So they have a sort of accredited email.
Yeah, exactly.
Oh, okay. That has to be registered once you register a company. And that's the email address that you should provide. Okay, very
exactly. Yeah, at the same moment you want to register a company, or even I am a lawyer, an Italian lawyer, so I figure as a professional, of course, and it is mandatory to me as well as my colleagues and also the various enterprises to have this kind of special protocol email.
Okay, interesting. And it does make much sense because the in the pre-internet world, if you register a company, you should have a physical address. But it makes sense that now you would have to register a dedicated email. But I'm not sure whether that's the case for companies in the Netherlands. I never heard of it. Interesting, very interesting. Also because it's a special email. Yeah.
Okay. So it does mean that in European countries, by the fact that, of course, all the national law systems could bypass, of course, this rule just because it is only a directive and not a regulation. So it is not mandatory for other traders in European countries to have at least an email address. I don't say a certificated one, but at least an email address where to be contacted.
Yeah, that's for the information site service provider. It is obligatory because the e-commerce directive prescribes that you should provide your email address. So there's no discussion that websites should always provide an email address. That's so. Once a company goes online and becomes an information site service provider, even if it's a very old-fashioned one or whatever, they should always provide an email address.
Okay.
It can be any email address. As regards to phone number, you can discuss whether it's possible. You can even you can decide to not have a phone number registered for your company, but then you can never call for your company. So that it's very unlikely that, but it's still a possibility. Yeah.
But if you see the new wording of this subparagraph C with the amendments of the 2019.
But what's the new wording?
The geographical address at which the trader is established, as well as the trader's telephone number and email address. So you will need to give always your telephone number, as far as
where available has been left out now.
Yes. Yeah.
Yeah, exactly.
Yes.
Yeah. And so fax number also.
Fax number is not here anymore. I don't know if we still have faxes. I don't know. I'm not sure. But
the interesting thing, I don't understand it, but there was someone who was arguing that this formulation that you were just quoting still left open the possibility to not provide your telephone number and email address. But I can't read it into that, what you were just quoting, but there are people arguing it still. I don't know why. But
probably because of my argument before. I don't know. I'm not sure. If you don't have a system, if you don't have a telephone number, for instance, or if you don't have a system which allows or within which you want to trade with a telephone number, you can still not have. I'm not sure. I'm just.
Yeah. But you can still argue. I would love to provide it, but I don't have a telephone number. You could still argue that.
I have no one to be on the other side of the telephone, for instance, in my business.
Nobody to answer the phone.
So I cannot guarantee that someone is is here to answer the phone.
Yeah, I was just talking about answering machines, but I once had a very effective answering machine because it gave me the information that made it possible to contact this company very rapidly. So I think they provided some form and I could fill it in and I got answer within like, that's a requirement of the ECG, by the way, about forms that they are effective if you get answer in like 30 till 60 minutes, which is for someone trading on its own quite burdensome, because if someone fills in the form 4 at night, how can you, maybe it's restricted to office hours, but still. So under circumstances, even answering machine might be very effective if the information they provide with the answering machine makes it possible to contact the provider effectively. What's also interesting
Thank you also, Simone, for your question. In Portugal, we also don't have that system.
No, very interesting. Yeah.
Yeah,
question, I think.
A unicum. I'll have Dr. Loder, only one thing. If you refer to machine learning as well as chatbots, for example, for financial services, yes, it is possible nowadays, of course, for commodity for customers and other business to interact with the trader, so with the bank institution or with the insurance institution, for example. But at least what it happens is that it is only a chat box, so there is no way to prove exactly what happened in the chat box for a consumer. So I think the directive is giving this kind of, and the rule is given only to make an insurance for the customer, just to have the situation to make a correspondence, a clear correspondence with the trader. Otherwise, there will be no sense for this rule, in my opinion.
Yeah, but it's interesting that you mentioned chat boxes because they are newer than these regulations. But that's of course also a very effective way to communicate with the. That's often used these days. A very effective way. Probably more effective than a phone number or an email address that you can on the site directly get information about. Maybe if the law would be redrafted, then these kind of communication means would be included. Although the information form even isn't in there yet. It's still quite old-fashioned. Email, fax, phone. So it's quite not really modernized in a way. So. Georgia, I think there was another question. I can hear you.
Yes, I had a question.
Hi.
I was thinking about the case of Uber because I've had many problems with them, and every time my order doesn't come the right way, I try to search for a phone number, and sometimes I find it, sometimes I don't. So when some random person posts it on the internet, I can call it, but the company itself, they don't post it anywhere, so there's no way to contact. And on the other hand, their email doesn't really work properly because it takes, for instance, once it took me 5 months to get my money back from an order that never came to my home. So it's not a rapid and effective and all the requirements from the directive. So even though they have the email, it doesn't count for the purposes of the Information Society Directive in order to be compliant with it, does it?
That's an interesting question. So I also once had a phone number for a plane ticket I ordered, and then when I called them, they only were talking in Spanish. So por favor is about the only Spanish I know. So that wasn't very effective for me too. I think that based on complaints, a consumer authority, for instance, in the Netherlands, might investigate what a company like Uber is doing. And if they don't provide an email address, it's clear. But if they get complaints that they provide an email address that even doesn't work, they still might sanction Uber in this respect. So I agree that they don't comply if it's not effective. And it could be enforced by authorities like in the Netherlands Consumer Authority, these kind of because that's the whole idea of these information requirements. These are the basic ones that you really want to have enforced, so that you know where they're established, that you can reach them, and if that, because that's so essential for distance contracting, that you can reach the other party. So if they don't comply with that, they're violating the law. But it's I don't even know if you install the Uber app whether they provide this kind of information like email, phone number. They should, but I doubt whether they really do. I have no idea actually. It's in no way, I think, rendered easily, directly, and permanently disinformation.
And especially because it's a company with so many complaints, they should have the proper means to comply.
Yeah, they should, yeah.
Thank you.
Yeah, I'm not thinking about these are financial services. In the Payment Services 2 Directive, there's an article about that payment service providers should have an effective complaint procedure. So that lines in what you were just saying. But that's not for information service providers in general, but for payment service providers. So there they explicitly have an article that deals with complaint procedures, that they should be in place and should work effectively. But that would be a good addition to for instance, the e-commerce directive, that information society service providers should have in place a mechanism that allows consumers to effectively file complaints. But that's not there now. Yes, Conchetta, you should unmute.
Yes, sorry. I found it very interesting also talking about Uber, because I had an experience on Facebook my question would be also whether that sometimes actually the information requirements, or like not the information, but like the way to communicate with the platforms is actually substituted by complaint forms. So, for instance, I had this experience on Facebook Marketplace where my post was actually removed without any reason. I mean, they actually didn't specify why, and there was only a report form where you can actually kind of appeal their decision, but I never received a feedback. And I looked it up whether there was an email address or something to contact them, and there wasn't. So actually, sometimes this way to communicate with, especially with online platforms, is kind of interpreted as we give you a tool for complain, or if anything goes wrong, we give you like help center, or you can, but they actually don't comply with these information requirements. And also I found it a bit strange also that in the Consumer Modernization Directive, they actually continue to, the formulation is still like the old one, where you can use geographical address, and actually it says like Article 6, paragraph 1, let us see, the geographical address where it is established, the traded telephone number, email address. So like, it seems to me that it's kind of old-fashioned for today.
Yeah, that's interesting. The initial idea about geographic address and means to effectively contact were if something goes wrong, because if everything goes fine, you don't need it. But it would be interesting to have a modernized version of communication with the provider, and also maybe specifying that they should, like in this payment services 2 directive, that they should have a good complaint procedure, and that's in particular for the distance contracting, so e-commerce contracts using apps, etc. You don't have this physical contact, so you should be able to reach out for the people you're trading with. So that's why it's very important, and it might be interesting for, I'm not sure if it would be interesting if some national authority would dive into those new big providers like Uber and Airbnb and how they provide this information and deal with complaints. That could be
do you think that in this case the Unfair Contract Practice Directive could play a role?
I'm not sure whether there are any clauses in this directive that particularly apply, but if not, it could be part of it. That it's about terms and contracts, infra terms. This is mainly, so in particular, like a Facebook platform, that's not really. Yeah, you can always construct kind of contracts, but it's mainly just a service being offered, and that's also why this Article 5 of the e-commerce directive is designed for information society service providers in general, not only for information society service providers that contract. So not only the Amazons, but also the Facebooks, the Googles, etc. They should all provide this information.
Yeah.
Yeah.
Okay. Thank you.
Yeah, so I previously mentioned the different phrases used for how the information should be communicated. Here it's interesting to see that in the Consumer Directive they discuss quickly also. They're not only effective, but also quickly. So there's sort of speed element involved, that you don't have to wait too long for, although that's sort of included in effectively, I think, but I'm not sure what the difference is between effectively and efficiently. I think that a linguist could have a very interesting study in looking into the different formulations in all kinds of EU legislations in this context. The E-terms, that I call E-terms, that there are specific information requirements related to e-contracting. This is it's interesting if you look at this list. For instance, I'm not aware of being ever really informed about the filing and accessibility of my e-contract. Maybe sometimes you get information about it. You hardly ever see your e-contract. You sometimes get a sort of confirmation email, but also one that I think I never ever been informed about is the languages offered for concluding the e-contract. So it's an information requirement. I'm not sure how, this is one of the examples where you might think, what value does it have to be informed about the language offered? If you're on an English website, then you wouldn't expect, of course, a Portuguese contract, even if you would be informed about it. So it's a very strange information requirements in a way. The one that was interesting in particular in the beginning is the technical steps to conclude the contract, because in particular in the beginning people didn't really know when the contract would be concluded, when the final step would be made. So if you would be informed about it, you could be sure that you took all the steps to conclude the e-contract. But this information also, the technical steps, is hardly ever communicated. Indirectly it is, so the process is often very clearly organized, that you order it, put it in your basket, get an overview, can look at it before placing the final order, etc. So technically it is well implemented, but in terms of information, getting information about it, it's not really. But also here you can question what sense it make to be informed about those technical steps, and whether really being guided through the process doesn't mean more than this information. But these are information requirements. So formally, everyone who offers e-contracts should provide this information, and it's also in terms of apps you would never get this information, but even on websites you hardly ever get this information. Then reference to code of conducts, then the general conditions, that's an interesting one to mention, must be provided so that they can be stored and reproduced. And there have been lots of discussions about this, when this information requirement is more how to communicate the information, general conditions, when it is complied with. In the beginning, people were very, and there's still attorneys advising that to their clients. They were really convinced that this could also only be complied with if you offer a printing option. And so they still advise, if you present the general conditions, also have a printing button that people can print the general conditions. What at least doesn't satisfy this is if the general condition is sort of pop-up window, because then you can't store it. It's there in a pop-up, and that's actually what often happens. Pop-up, okay, agree. So that actually doesn't comply with this condition. Although even there you can argue, it has been argued for providing a link to general conditions. And there have been judges that ruled in different ways about it. Some judges don't think that general conditions are provided if there's a link provided to the general conditions. That's not enough. It should be really able to store it and reproduce it. I think that everyone is capable of storing information that's presented on a website. Well, that's my idea. And that you can even say, sometimes with a pop-up, you can select all the text and put it in a document. So if you want, you can store it. But there's some discussion about this general information. What's of course also interesting is that nobody ever is interested in general conditions in the physical world. But now when it turned to the electronic world, and suddenly they had to be provided, and well provided, etc. So yeah, there's one last point about general conditions is it was interesting. I'm not sure how it is in other countries, but in the Netherlands, it was defined that if you're contracting electronically, then you can provide the general terms in an electronic way. And there was a court case about people contracting non-electronically, but providing the general terms electronically. So that didn't comply with how it was implemented because the contract wasn't electronic. But then the judge argued, well, it was in 2007, I think. Nowadays, the electronic presentation of the general terms equals physical presentation. So there was a very original argument, and it later has been changed in the law so that also with non-electronic contract you can present the general conditions in an electronic way. So it might be different in different member states, how they implemented it. But it does, of course, make sense, in particular because you hardly ever been handed over the real general terms. If also in a physical contract you are referred to a website, then at least if you want, you can read those general conditions. So it does make sense also for non-electronic contract to present the general conditions in an electronic way. And then the quote in the bottom I referred to before is that those information requirements are not general information requirements like the Article 5 of the e-commerce directive, but only apply to consumers. But business parties can agree to apply them, but I think they will never do. This is in terms of the information overload. It's interesting. So we discussed only a small part. In particular, the consumer directive has like 15 different information elements that have to be provided. So there's a lot of information that have to be provided. But in the consumer directive, they indicate that the information requirements of the consumer directive are in addition to those in the service directive and the e-commerce directive, but it do not prevent member states from imposing additional information requirements. So there can be even more information requirements. I think that there may be sometimes a very particular information requirements just make sense, but I don't think it normally add much to what already has been drafted in those directives. Then about how to present the information and the substance. If it conflicts with provision of that's interesting for the interpretation of Georgie, because I was saying emails no discussion, because email based on the e-commerce directive should be provided, but here it says that the provision of this directive, the consumer directive, prevails. So if George's interpretation of where available, that no longer is there now, but was correct, then it could overrule the e-commerce directive actually. I know it here. So I didn't know that it was that. So it's the newest one, of course, the consumer directive, but it's also the highest one in order of which one prevails, the consumer. Contract formation. I think shall we just finish without break now, Georgie? Is that fine for you?
I'm sorry.
Is it okay for you if we just finish without having?
Yeah, of course. We can finish.
Yeah, so one of the things that was regulated in the e-commerce directive was that the national law should take away elements that provide contracts from being concluded electronically. So member states must have done it like 20 years ago. So if there were some like in writing, can be something that could be discussed about where that you can either have a clause that says in writing also includes electronic, or you can interpret it that way, but you should pay attention to that. So each member state legislators should have gone through all their legislation and seeing whether there are elements like physical presence of parties and things that make it impossible to conclude electronically, and then it should be taken out of the law, so to allow for electronic contract. Some exceptions like house, property, and that kind of things were there, but basically every contract that can be concluded should be able to be concluded electronically. And there has been a lot of discussion also about the conclusion of the contract, because in the beginning the people were very frightened that a contract would be concluded without people being aware of the fact that the contract was concluded, so that you would click an OK and that you would then be stuck to a contract. So in the beginning they were thinking about a four-way handshake, that there was an offer of a website, and then an acceptance, and then the website should confirm the offer, and then the recipient should confirm the confirmation of the offer, and then it would be concluded. But in the end, they skipped that.
That's the solution of the.
Some countries. Sorry.
Sorry, Arno, to interrupt, but that's the solution of the Portuguese Legal Act, e-commerce act.
The four-way handshake.
The four.
Oh, interesting. Because there were some countries, I think Spain, where delivery is part of the conclusion of the contract. So then it would have been too much infringing on the civil law. That's why they skipped this whole idea. How interesting that they have the four-way.
In my opinion, the third and the fourth are already contractual obligations or part of the contract. In my opinion, the contract is concluded after the acceptance.
Oh, okay.
And then there's an obligation for the trader to acknowledge the receipt of the acceptance, and then the consumer can, or the party, the other party, can determine the production of effects of the contract, but not the conclusion of the contract.
Okay.
Okay, but it's a
the idea of the first proposal in the e-commerce directive was to have it as a constitutive element, so that the contract would only be concluded after the 4 steps. It's sometimes, in particular, the confirmation by the provider makes sense, because then you know that your order has been correctly placed, and that's basically what happens in practice. You normally get this email or things so that you know that the contract has been concluded. So in practice, it works. But the regulation is now that the main rule of offer and acceptance remain applicable, but the supplier must confirm as soon as possible. And that's what basically happens in practice. Yeah, and then the accessibility is not necessary to discuss this now. So, but it's important to understand that the confirmation based on the e-commerce directive is not part of the formation of the contract. That the contract is already formed, but the confirmation is just an additional information requirement from the e-commerce directive. Then this is a very very interesting one from the consumer directive about contract formation. So if you place an order, the button or similar function shall be labeled and easily only with the words "order with obligation to pay" or a corresponding unambiguous formulation indicating that placing the order entails an obligation to pay the trader. So pay now, that seems to be clear. Click to pay now. But if you have, instead of pay now, order, then it doesn't comply with this requirement, and then you, based on this article, you wouldn't have a contract. It doesn't make much sense, but that's what it says. If the trader has not complied, the consumer shall not be bound by the contract to order. So maybe it's interesting to look on the internet for all kinds of websites that don't have this button and order there and then don't pay. And if you don't pay and have it delivered, you say, oh, I just read in the... but then probably have to... if there's no contract, there was no reason for the company to send it to you. So I think, is it then inertia selling? So would you be obligated to return it, or could you say, well, I don't think that you could have an argument and say, well, I got it without asking for it because you did order it, but not in a legally valid way. So in the end, it won't help you, I think, by keeping the items. It's interesting to confront the provider with it. That, we didn't conclude a contract, by the way, and then refer to Article 8, subsection 2. Then the withdrawal period that will be discussed later, so I will be very briefly on this topic. What's important, I told you in the beginning about the tell cell, and that also applies to distance selling and e-commerce in general, is that you have the option to return it. That's a legal right you have, and it's different from physical purchases. So I give the example of the bookstore in the university. If you have bought there something physically, it's a courtesy to have you to give you the right of return. They're not legally obligated to it, and they don't have to return your money. So they can also return a voucher that you can buy something later. If you buy it online, you have a legal right to get your money back. So they must give back your money if you paid with money. So that's a legal right that you can't circumvent. You just should comply with, and that's an important enabler of distance selling, because people know that they have the option to return items. The period you have to withdraw is 14 days. What's interesting is that there has been a lot of discussion, because in the distance selling directive it said like 7. I'm not sure whether it said working days or days, but it was implemented differently in all kinds of member states. So some member states had 14 days, other 10, other maybe 21, whatever. And this was meant to harmonize. So 14 days to withdraw. And it's just 14 days. So if Christmas is part of it, it's still 14 days. But for instance, in Decathlon, the sports shop, you have 365 days, even if you buy it physically. So you see that sometimes in practice, it can go further than what the law requires. But if you buy something online, you always have the right to withdraw from the contract 14 days within a period of 14 days. Without giving any reason, so you don't have to say why you want to return it, and without incurring any costs. So you don't have to pay anything other than provided for in Article 13.2 and 14. And that's the cost of returning the item. So the provider has to pay the cost for delivering. So if you have paid, that's an interesting thing to mention. So it might be that you have to pay for delivering an item, but if you withdraw, then you have to get that money back for delivering. But if you have to return, you have to pay the money for returning. So it's a sort of maybe counterintuitive that you pay more for a product being delivered to you that you keep than for a product that you return. It has something strange in it. And there has been lots of discussion also about this right and the burden on e-commerce companies that get many items returned. So people that offer like 5 pence and return 4 of them. And there has been thinking about whether that should be changed or made differently. I don't know. You can think of all kinds of schemes that that remedy this burden on companies. But as for now, it's still a legal right you have within the European Union.
When in the fitness check and now in the there has been discussions around this topic, and the truth is that in the final version of the new directive there were no changes on this issue.
Yeah. Interesting. So there's an exception to the cost. So if you ask for express delivery, you don't get all that money back. You get only the money back for normal delivery. So that's exception to the cost that can be beared upon you if you return an item. And I already told that the cost for returning are on the consumer unless the traders agree to bear them, and that's what often also happens. Or, and that's a violation of the information requirement and a sanction on it, if the trader failed to inform the consumer that the consumer has to bear them. So if by offering the product, the trader didn't inform the consumer that in case of using his right of withdrawal, he has to pay for returning it, then you don't have to pay for it. So that's a sanction on the violation of that information requirement. So these are this is the very long list of information requirements in Article 6.1, and H is about explicitly the right of withdrawal, where a right of withdrawal exists, the conditions, time, limit, and procedures for exercising that right, as well as the model withdrawal form set out in Annex 1B. And that's an interesting one. I have it here. These are the model instructions, and I think this is the form. Has anyone ever seen this form? Maybe you sometimes have it in the, but this is obligatory by law that you get this form when withdrawing from the contract. There are some exceptions to your right to return: flowers, perishable goods, tailored suits. So that you can't return them because they were targeted, made for you. In the Netherlands, there also has been an interesting discussion about ordering cars at a distance, whether you would be able to return the car because it's already registered, etc. But the basic idea is that even if you order a car, you would be able to return it. It's maybe a bit far-stretched, but and then not often happening, but theoretically you would have that right. Then there's an interesting recital about because there has been case law. The right of withdrawal, the idea is the touch and feel. So if I order this cup, I can, if I have it delivered, touch and feel it and think, oh, okay, I want to keep it or not. That's the rationale. So exercising that right before you get it doesn't make sense because that's not what the right is for. So there have been cases where people ordered something, canceled it before it being delivered, and then the seller, the trader, didn't want to annul it. They did want to send it. So if you look at why you have the right of annulment, it makes sense because it's for the touch and feel. But practically, it's of course quite stupid if people want to exercise this right before it's being delivered, that you still want to deliver it. So that's why now there's this recital that you can also exercise the right before acquiring physical possession. So if you change your mind, you can say, well, I don't want it, just to not have it being sent up and back without any reason. Then you should inform, provided that you use the right of withdrawal within a certain period, within the 14 days. And normally what people do, and that's also working, that you send it back and then the trader is informed by receiving the returned item. So that's practically coming down to the same. But it's the form, the legal form, that should be used by every trader at a distance. And this is the last slide. So there are information.
Simone, just Arno, we have a question.
Yeah.
Simone.
Yeah.
Am I allowed? Can I make a question?
Yes, of course.
Yeah, sure.
Okay. Yeah. About the possibility and the right of withdraw for customers. Is there a topic inside studies or researchers about the fact that many times the fact that the goods are not so expensive, the transport, and so the giving back of the good of the same good could cost more than the same good? So there would be a kind of frustration of the right of withdrawal for customer in this case.
I had an interesting personal experience. Yeah, I think it makes. Yeah, so if you buy very cheap items, then it would cost you more to return it than the item really costs. Yeah. I think that's the.
Has it ever been investigated by researchers or studies? Yes, this kind of problem, because for many it is a problem in the sense that the customer has already acquired the possession of the good, but he decides he's frustrated to exercise his right of withdrawal simply for the cost of the transportation, because maybe sometimes they could be over than the cost of the goods, of the same goods.
Yeah, I think that personally, I would say that's the risk of buying online. If you buy very cheap things for like €3 or €4, why would you have this? I agree that you can exercise that legal right of return, except if you, because that's often these days also more and more happening, that you can return it in physical store. So then it doesn't matter. You can still return it and you don't have the costs. But then you can even return cheap items. But that's something I think the consumer has to take into account. I had a bit in line with your question. I had a very interesting personal experience when I ordered a blender. Not the blender itself, but the glass thing where you put the thing in. And I was really, because I thought, finally, I don't buy something new. I buy a sort of replacement of what has been broken. So I was very fond of myself that I bought it. But it didn't look very well, because when it was delivered, the knives weren't included. And I had thrown them away already. So I couldn't use this blender. Then I looked at the website, and ordering the knives was again like €15. And then I was thinking, well, that's too much. So I wanted to return this blender. And I filled in the form, so I notified them. And then I was called by, I think it was Philips. You want to return it, but it has been delivered from Poland, and it cost us more to return it because they said they would bear the cost for returning. So are you okay with it to keep it without being incurred any costs? So for free, I had this thing. And they had two conditions. One, that I would not sell it. And two, that if I would throw it away, I would do it in an environment-friendly way. So I agreed to that, and I think I still have it. I sometimes use it in classes to show people. So that sometimes traders can do if it's too costly for them to have the items returned. And the same argument can apply to consumers if they have to return cheap items. But I think that's something you. I also, you often also have that above a particular price, you don't have to pay for transport costs. I think that's our considerations you should leave to the consumer, and he can also think about, and that's again why cross-border is more difficult, about delivery, that you can pick it up as a shop, can be cheaper, and can return it there. These are things that the consumer should take into consideration. So, so my final question, and it's not very clear from what I have discussed, because I only discussed a very small part of the information requirements, and only quite important ones, except for the conclusion of contract information requirements. But there's much more, and it's an interesting question to think for yourself. What information is really required if you buy something at a distance? What's the essential information? And maybe shouldn't the law be restricted to that? There has been a lot of discussion about who benefits from all these information requirements. And it appears that basically the people the more informed consumers benefit from getting this information, and the people that would really need it actually don't benefit from it at all. But maybe that's a general consumer problem. I don't know. Yeah. So that's yeah. And I had to think about this case about the couple from the UK that bought a very expensive watch from all their savings money for like £10,000, and when it was delivered, it was a picture of the watch. So the main characteristic of the item weren't disposed by the seller. But this is an example of fraud, and fraud you can't remedy with information requirements. So you have to. The idea is that you can inform yourself about the trustworthiness of a trader. All these information requirements, you can check things about them. You can check things about the products, but fraud you can remedy with these kind of with this law. So that's mainly what I wanted to say about this topic.
Thank you so much. I don't know if you have other questions. I think you were during the, at least Simone and Conchetta and Sofia asked a few questions here. I don't know if you have other questions.
No, I already received the answer, so it's okay. Thanks.
Thank you, Simone. I also think it's a question, if you buy something ship online, it's also your risk. And I agree with Arno in that part of the answer. So no other questions?
Well,
well,
I don't know whether it's a question or maybe it's just
or a comment.
For discussion. Yeah. Well, I actually I agree with the idea that these information requirements in the end sometimes may be more detrimental for consumers than useful. And in this, I actually address the topic of information requirements also from another legal perspective, that is the one from legal design. So there is a lot going on about legal design techniques, and even though I'm still quite skeptical, because in the end we actually saw before with the example of Uber or platforms in general, that in the end until we don't have like enforcement agencies and authorities that start investigating in this business operator, all the requirements are in the end quite ineffective for the consumer protection. So, well, yeah, this is just a comment. It's not a proper question.
Yeah, that's the enforcement is a good point. So particularly in the beginning, there wasn't any enforcement at all, and some sanctions can be enforced by the consumer itself, but in particular the penalties should be enforced by the authorities. Yeah, in particular what we discussed, the Ubers and the Airbnbs might be interesting ones to look into. Although the Court of Justice, of course, ruled that Uber isn't an information society service, so the information requirements do not apply to them. Actually, isn't that strange? Yeah, that's strange. But that's what the Court of Justice ruled. So I think that the Consumer Directive applies, but that applies probably. I think that the Consumer Directive applies both in the contract between you and Uber as having this app, and between the driver and Uber.
Yeah.
Yes, I agree.
That's contract. But the strange thing
different
is that
contract with different. Well, with Uber, I would say with Uber, the problem is that we contract directly, at least in my opinion, under Portuguese law and in general, I would say you contract directly with Uber. You can you cannot say that you have an intermediary. The driver, at least in my opinion, is not part of the contract. The contract is included.
Yeah, that's an interesting point. But then also because in terms of consumer directive and distance selling, so the things we discussed today, we have physical contact. Although until the contract is concluded, it was at a distance because you're using your app. So I think the consumer directive information requirements still apply, but then they apply to Uber and you, and not to the driver, and because the driver isn't an information side service provider. He's just taking you from A to B. Although you have a, I think I agree with Georgie that the contract is concluded with Uber, not with the driver, because the driver is given to you after you ordered this service online. So that makes sense. Yeah.
And also,
I don't know. What is your opinion on this topic and the Italian law? Is the contract concluded?
Well,
we have three parties in the.
Well, it's still under discussion, and not a lot is going on about the legal qualification of contracts in platform economy. This is also the topic of my PhD thesis. So
I know. At least it's part of.
Well, I'm actually trying to challenge the construction of this trilateral configuration of contract because sometimes it depends a lot on the business model that we are considering. So, and so it's there is no one size fits all approach that can we follow. But definitely it is, I think that regarding the topic that we addressed today in the platform economy, there is an interesting question about that we have to consider when the structure, so the environment of a platform doesn't allow the provider or the trader to comply with the information requirements under the Consumer Rights Directive. And this is an interesting point. Yeah.
Yeah, that's one that hasn't been remedied by because it has been a discussion for long already. How you can comply with information requirement if you're using a platform that doesn't allow you to comply in a proper way. But I think it hasn't been remedied by the recent regulation and directive that applies to these online platforms. But it should be part of it actually. Yeah, it's a good point.
And just when note, the directive on consumer rights does not apply entirely to for passenger transport services.
Okay.
So it only applies Article 8, paragraph 2, and Articles 19 to 22. So the distance contracts provisions do not apply to passenger transport services. So it wouldn't apply.
Okay. Yeah.
Uber. I was opening the directive to check.
Okay. Maybe the service directive does.
Article 3, paragraph 3, subparagraph K.
Yeah, but maybe the service directive does. So the 2006.
Yes. So thank you so much, Arno, for being here today at the Nova School of Law. Even being in Amsterdam and far from here. Hope to see you soon, physically present, both of us. So I hope you can come to Lisbon in the near future, and all this situation is over. We hope
it doesn't take too long and will be too detrimental to everyone.
Let's hope.
Yes.
Thank you so much. We will end now this seminar. I will ask for the students of the digital contracts course to remain here, so we can talk 10 or 15 minutes about the articles and everything. For those who are not from the course, the seminar ends here. Now we are going only to discuss the practical issues related to the course.
Okay.
If you want, the next seminar of this series of seminars will be held on the 27th of April. Lucila de Almeida from the Tel Aviv University and European University Institute is going to talk about digital contracts and services of general interest. If you are interested in following also this seminar, I will ask you, I'm talking to Gonçalo, Simone, Concheta, Sara, Ana, João, and I think it's all of those who are here today. You can send me an email. It will not be the same link. So if you are interested in the other seminars, you just need to send me an email, and I will send you the link to the following seminars. We will also have 3 seminars in May with Sergio Cámara Lapuente, Christian Twig Flesner, and José Antonio Castillo Parrilla. And so it's a great pleasure to have you here, and assist. And thank you also, Simone and Concheta, for your questions and for
yeah, thank you.
Thank you too.
And see you. Thank you, Arno. I'll send you a message thanking you again after this class. Thank you and see you. Bye.
Bye. Bye.
Bye bye.
Bye.